Well, good morning, everyone. My name is Dwight Newman, and as chair of the University of Saskatchewan College of Law Speakers Committee, I'm pleased to welcome you to the 2025-26 academic year's final winter lecture in the McKercher LLP lecture series. So there are still some upcoming speaker events organized within other series that you'll be hearing about, the upcoming Saskatchewan Law Review lecture in February, and then the Stack lecture occurring in Regina in May. As we gather here today, the University of Saskatchewan wants to acknowledge that it's on Treaty 6 territory and the homeland of the Métis. The university pays its respect to the First Nation and Métis ancestors of this place and reaffirms its relationships. On a lighter note, I'll say if you've not entered for the door prize, there are door prizes on the left of me, and they'll be out till after the lecture, the chance to enter. I was suggesting that we should have, for reasons that you'll know soon, a sports car, but that wasn't in the budget quite. So there's no sports car in the door prize, but there's some nice things there. So do feel free to enter for that. It's great to see all of you here and engaging with the speaker. I'd like to just quickly acknowledge some of the people who are here today. I'd like to begin by thanking McKercher LLP for sponsoring the lecture series here at the University of Saskatchewan College of Law. Their sponsorship allows the college to continue to present a wide range of informative and educational and sometimes entertaining speakers to the law school community. And appropriately to a lecture on M&A, we have some lawyers here today from McKercher's significant M&A group, and I think some other lawyers from LLP as well. So welcome to the McKercher group. If you want to give a quick wave so everyone can say hello if they wish after. I'd also say lawyers in our community here in Saskatoon give back to the college in many different ways. I'll quickly acknowledge some others who've given back through their time in teaching. I'll just mention, I'm sorry if I miss anyone, but long-standing sessionals like Chris Donald, who's taught our Law and Economics class for many years, and Bob Kirkpatrick, who's taught our Securities Regulation class for many years, so it's nice that they could come as well. We have various other people here, and there are many others we could acknowledge as well. But I might briefly mention Gail Henderson, who's normally at Queen's University, and if you've not met her yet, she's our SD visiting chair in business law this semester. Gail, if you want to give a quick wave. And she's teaching a consumer protection course at the college, and she'll be organizing a conference or workshop in May that you may hear more about in that business law area that we're so keen to foster. We're also glad to have Dev Mishra here, who's the Edwards Enhancement Chair in Business, who's in the Finance Department over in Edwards, and others. We could mention University of Alberta Emeritus Law Professor Tamara Buchwald, who used to be here at one point, and but others as well. So thank you to everyone for coming. I also want to, because this is our last lecture, I want to thank Professors Birmingham and Ponomarenko for serving on the Speakers Committee this year. Also, Austin Goyer and Tyler Slaney, who've been the student members on the committee. And they've all done a lot of work in putting together the speaker events. Different college staff have contributed, of course, as well. Danella Hoffman on the communication side, Stacy Shawaga on development. And I don't know, Katie may have left to organize something else, but we owe so much thanks to Katie Richard for all of her work supporting the speakers program throughout the year. And so I'd just like to note that and extend very much our thanks to her. I have now the privilege and pleasure of introducing our speaker today. Camden Hutchison is an associate professor at the Peter A. Allard School of Law at the University of British Columbia and the director of their Center for Business Law. Professor Hutchison holds a BA in history from the University of Rochester and a JD from Columbia Law School. Before returning to graduate school, he practiced as a corporate associate at the law firm of Kirkland & Ellis in Chicago, in their Chicago office, where he represented private equity firms and public corporations in connection with mergers, acquisitions, and other corporate transactions. Prior to then going on into academia, Professor Hutchison also earned his PhD in history at the University of Wisconsin-Madison, where his dissertation examined the history of corporate regulation in the 19th and 20th century United States. His research and teaching focuses on corporate transactions, comparative corporate governance, and the historical development of corporate law. He's also published on corporate taxation and competition law. His current research focuses on directors' duties and shareholder rights in international contexts, or some of his current research. Outside the scholarly realm, I learned yesterday that one of his hobbies is that he does road racing in his sports car, legally as part of a car club, I should add. With such a wonderful speaker here, I don't want to take more time. I just hope you'll join me in welcoming Professor Camden Hutchison.
So thank you very much. My name is Camden Hutchison. As alluded to, my research and teaching focus primarily on corporate transactions, which is what I will be talking about today. And on my introductory slide, I have a picture of a used car. So this is a pre-owned BMW. This is not just any used car. This is literally my car that I bought. So you might be wondering, why am I showing you a picture of my car? Well, there's two reasons. The first is, obviously it's very cool. That's one reason. But the second reason is that buying a used car shares some similarities with buying a company, which is going to be the focus of my lecture today. So when you buy a used car, you are encountering a information asymmetry problem. The seller of the used car knows much more about it than you do, right? The car may have hidden issues or problems that are not apparent upon visual inspection, right? The car may have been in an accident and then subsequently repaired, which is not a good thing, right? The car may have been stolen and subsequently recovered, which is not a good thing. The owner of the car may have raced it on a racetrack, which is not a good thing, right? So there's a lot of hidden or unknown issues that the seller knows that you don't when you're buying a used car, and buyers of companies in the M&A space encounter similar problems. So my lecture is going to focus on this issue of asymmetric information. Asymmetric information is a fundamental economic problem in all forms of contracting. Information asymmetry is a function of imperfect information among potential trading partners. And it refers to the fact that buyers and sellers of goods and services have unequal information about what is being bought and sold. In general, sellers of goods and services have more information than buyers, right? So the seller of any asset has more information about their asset that they're selling than any potential buyer, right? Why is that? It's because it is theirs, right? They possess it. They control all of the information about it, right? They know if it has any hidden defects or any hidden problems, any strange issues. They have more information about what they're selling than the buyer. Buyers with imperfect information rationally fear that sellers will take advantage of them. This concern reduces the price that buyers are willing to pay and sometimes prevents transactions altogether. To the extent that information asymmetry reduces transactions, it also reduces economic efficiency, in that welfare-enhancing trades fail to occur due to information problems. And this is a form of market failure. So economists define market failure as any situation in which markets fail to efficiently allocate resources. Right? That's the definition of market failure. And information asymmetry is one of the major causes of market failure. So how does that relate to the market for companies? So just like cars, houses, and other variable quality assets, information asymmetry is an issue in the market for buying and selling companies. So as I mentioned in my introductory slide, buying a car, the seller may be privy to hidden information that the buyer is not, so there's information asymmetry in buying a car. Anyone who owns a home, right, when you buy a home, there could be hidden issues with the home. I live in Vancouver, so I wouldn't know. But if you buy a house, it could have termites, right? It could have, I don't know, cracks in the foundation. It could be haunted by a vengeful spirit. It could have a number of hidden issues that you don't know about as a buyer, right? So there's information asymmetry when you're buying a house. And there's also information asymmetry when you are buying a company. Now, all of these markets, the market for cars, the market for houses, the market for companies, in all of these markets, information asymmetry problems are mitigated by innovations that have been developed by market participants in order to solve these kinds of problems. So, right, like in the used car market, for example, before you buy a car, you want to perform some kind of due diligence on the car, right? The most common example of that is you would get the Carfax report, right? You would get a research report from like a third-party research organization that they'll give you the history on the car. Has the car ever been stolen? Does it have a salvage title, et cetera? You might have a buddy who's into cars. You might bring him or her to look at the car. They can, suss out where it has any issues. If you're buying a used car, certain luxury brands, like BMW, for example, they have certified pre-owned programs, right, where the car is certified by the manufacturer and they will actually offer you a warranty, right? So if things break in their car, you can get it repaired. So like my car was a certified pre-owned, right? So it had a warranty when I bought it, right? Similar with houses, like, there's all sorts of, legal and business solutions to information asymmetry in buying houses. And the same goes for buying and selling companies. So in the M&A market, sellers know much more about their company than do potential buyers. They know its past financial performance. They know its projected financial performance. They know if it has any potential legal liabilities, right? Business firms are very, very complex entities, right? And, business is very complex, and private businesses are highly opaque, right? It's very difficult to tell what is going on with a private business from the outside, right, if you're not privy to private information. So without effective methods for resolving these information asymmetries, the M&A market would be severely limited, right? The M&A market would be severely limited because buyers wouldn't trust sellers, right? So there would not be a lot of buying and selling. Fortunately, creative negotiation and contracting can resolve many of these information asymmetries. Okay, so I've introduced the general topic of information asymmetry, and now I want to talk about two specific forms that information asymmetry can take in the marketplace, or two specific ways in which information asymmetry manifests. The first is adverse selection, and the second is moral hazard. So adverse selection, also known as hidden information, is when one party possesses information that a counterparty lacks. Moral hazard, which is also known as hidden action, is where one party acts without a counterparty's knowledge. And these two phenomena are at the heart of nearly all contracting problems. So to just give you a quick example of what adverse selection and what moral hazard is, I will use the example of the insurance industry. All right? Economists love to study the insurance industry because the insurance industry is characterized by both adverse selection and moral hazard. So the insurance market is a lot different than the M&A market, but we can use the insurance market to explain the general concepts of adverse selection and moral hazard. So adverse selection in the insurance market is due to the fact that people or individuals who are at risk of suffering a loss are the most desirous of buying insurance. That's the adverse selection problem in insurance markets. So, for example, people who live in areas where there's a lot of flooding are the most eager to buy flood insurance, right? People who live in areas where there's lots of fires are the most eager to buy fire insurance, right? People who live in areas where there's a lot of property theft, other things being equal, are the most likely to buy theft insurance. A very, dramatic example of this, I suppose, that you see in the United States where there's private health insurance markets. There's not in Canada, of course, but in the United States where there's private health insurance markets, people who are very ill are the most desirous of buying health insurance, right? Now, this is a big sort of economic and business problem for insurance companies because insurance companies make money by collecting more in premiums than they pay out on their policies, right? So from the perspective of an insurance company, the people who are the most eager to buy their products are their worst customers. They're adversely selected. The people who are most likely to experience a loss are also the most likely to buy insurance, right? So they're adversely selected. That's an example of adverse selection in insurance markets. Insurance can also explain moral hazard. So moral hazard in the insurance market refers to the phenomenon that people who have insurance often change their behavior in a way that increases the risk of loss, right? So like maybe prosaic example of this is like imagine use the theft insurance example, right? So imagine someone has like a big mansion and they buy theft insurance, right, to protect against, I don't know, any break-ins or any burglaries or whatever. Maybe not a big mansion, whatever. They have a house. They buy insurance to protect against robberies or burglaries. And then they have to make a decision about whether or not to invest in an expensive home security system. Let's imagine a home security system, I don't know, it's like thousands and thousands of dollars. It's quite expensive. And they're trying to decide whether or not they should buy a home security system. Well, they might think, I'm insured. So, God forbid somebody breaks into my house. But if they do, the insurance company will cover the loss. So on the margin, I'm not going to invest in a home security system, right? The fact that they are insured actually increases the likelihood that the loss is suffered, right? This is moral hazard in the insurance industry. A more extreme example of moral hazard would be somebody takes out a fire insurance policy on their house and then burns down their own house to collect the insurance. That would be an extreme example of moral hazard. So that's adverse selection and moral hazard, and we see these in the M&A market as well. So adverse selection. Under conditions of imperfect information, market participants who possess adverse information will be most willing to sell or buy, right? So if we think about the market for companies, we can expect that companies being sold are of systematically lower quality than companies that are not being sold, other things being equal, right? Because if a company is really high quality, the owner is less likely to sell it. If a company is of really low quality, other things being equal, the company is more likely to sell it, right? Now, of course, not all companies being sold have quality issues. I mean, not all companies being sold are low quality. There are many innocuous reasons that people sell companies, right? They're selling for strategic reasons. They're selling because they need liquidity. They're selling because of some kind of lifestyle change. They're retiring. There's some kind of success issue. They're selling because they just get a really good offer. So there's lots of innocuous reasons that people sell companies. I'm not suggesting that companies that are being sold are of systematically low quality. I'm suggesting that they are systematically lower quality than companies that are not being bought or that are not being sold on average, right? So market participants who know this and who lack information, they may be hesitant to enter into trades, right? The mere fact that someone is selling a company is almost like a red flag as to the quality of the company, right? If someone is selling a company, if someone is selling a business, right, the first question you want to ask yourself as a buyer is why? Why are they selling this business? And again, there are many innocuous reasons that they're selling the business. But, it could be because the business is not performing well, right? It could be because the business is not meeting the economic or financial expectations of the owner. It could be because the business is in economic or financial distress. It could be because the business has horrible legal issues, right? So, that's what you want to be concerned about as a buyer. Now, this concern, this asymmetric information problem, can result in markets functioning poorly or not at all, right? If buyers and sellers are not able to figure out this information asymmetry problem, markets break down. And given the opaque nature of business firms, the market for corporate stock and assets is characterized by this adverse selection problem, right? Like I said, private businesses they're very opaque. You look at a privately owned business, right? You might, if you're a potential buyer, you're like, hey, I want to buy, I don't know, this retail business or what have you. And you might try to assess the business, from the outside, and you might say, wow, this business, it looks like they're doing great. They're selling lots of products. Customers are lined up around the block. This looks like a fantastic business. But you don't know, right? You don't know what the business's cost structure is. You don't know what their margins are. You don't know if they're making a profit at all. They might be they might be taking a loss on every single product that they sell, right? You don't know anything about the economic structure of the business, right? And it's very hard to assess that without access to private inside information. Now, I'm speaking, to the private company M&A context, which is kind of my background and my interest. If we're talking about public companies, the situation is a bit different because public companies are subject to public disclosure requirements, and so they are much more transparent. It is much easier to look under the hood for a public company than for a private company. And if I have a little extra time, I might speak to that distinction at the end. But for present purposes, let's assume that we're dealing with private companies. And I would say even for public companies, there's still an information asymmetry problem, right? Public companies, they don't have to disclose everything, right? And their disclosures may be inaccurate. So there's still an information asymmetry problem in public company M&A as well. Okay, so how does moral hazard manifest in M&A markets? Well, moral hazard in general arises when one party to an economic relationship cannot observe the actions of their counterparty. And if a party's actions cannot be observed, it creates incentives to act opportunistically. Opportunistic behavior often results in hidden costs and economic inefficiency, right? A disloyal agent, or a opportunistic counterparty, they can, in effect, impose externalities on their counterparty. They can impose hidden costs on their counterparty, and because they don't have to internalize those costs, they will provide, sort of too much in the way of costly behavior from an economic standpoint, which results in economic inefficiency. Corporate governance is an excellent example of the moral hazard problem. So I teach a corporate transactions course. I also teach our business organizations course at UBC. And in my business organizations course, I focus a great deal on what are known as agency costs, which is how moral hazard expresses itself in the corporate governance standpoint. So I'll just kind of maybe speak about that a little bit. So companies, as I'm sure you know, if you've taken business organizations, or if you are taking business organizations or corporations or a similar course, corporations are managed by directors and officers, but they are owned by their shareholders. Now, for small privately held companies, the management of the company and the ownership of the company is often the same, but for larger publicly traded companies, there is a separation between the ownership of the firm and its management, right? So the directors and officers of like a large public company, for example, typically own relatively little in the way of corporate equity, right? They are managing the corporation on behalf of the shareholders who own it, right? They have, in effect, been hired by the shareholders to run the company, right? The shareholders are the principal, and the managers are the agents, to use the language of agency law. Now, this creates a moral hazard problem. The most extreme example of moral hazard in the corporate governance context is embezzlement. That would be the most extreme example, right? So imagine that, the CFO of a company, right? Imagine that they divert corporate funds into their own bank accounts surreptitiously. They're stealing from the company. That's an extreme example of moral hazard, right? The shareholders cannot effectively observe what the CFO is doing, so the CFO is, dipping his or her hand into the cookie jar and stealing money. That would be an extreme example of moral hazard. A much more common example of moral hazard, and I could give tons of examples, but a much more common example of moral hazard is what economists refer to as shirking. So shirking is a more common example of moral hazard, and shirking simply refers to a situation in which corporate management, or any agent for that matter, exerts less than maximal effort. That's shirking, right? You cannot observe what management is doing, and so management has an incentive to shirk. So if you think about the management of a company, from the perspective of the shareholders who own the corporation and are entitled to the residual economic value of the corporation, what they want the managers, like the CEO, let's just use like the CEO as sort of a proxy for all managers. What they want the CEO to be doing is they want the CEO to be absolutely killing themselves, working 24 hours a day, 7 days a week, in order to maximize the profitability of the firm, right? They want them, ruining their life, neglecting their family, right? They want that, like Elon Musk when he was in the 60 Minutes interview and he was like, I'm sleeping in the Tesla factory, and he like broke down in tears. Like that's what they want, right? They want a CEO who's just ruining their life in order to maximize shareholder profits, right? The CEO obviously has different incentives, right? The CEO wants to relax, right? The CEO wants to go golfing on the weekend, right? The CEO does not have the same incentives as the shareholders, and if the CEO can get away with shirking, they will, right? If they can get away with exerting less than maximal effort, they will. So there's always a misalignment of incentives between corporate management and corporate shareholders. And there are a number of contractual methods to realign those incentives that I'm actually not focusing on for purpose of today's lecture. But if you study corporate governance and you study how corporate managers are compensated, you'll know that the structures that we use to compensate corporate managers of public companies are designed to incentivize them to really focus on maximizing the profits of the firm. Okay, so that's adverse selection and moral hazard. How do adverse selection and moral hazard express themselves in corporate contracting? Well, adverse selection and moral hazard are pervasive in all forms of corporate contracting, including M&A. Fortunately, skilled lawyering can help mitigate these problems, and this is what I try to teach my students in my corporate transactions course. Adverse selection, for example, can be resolved by disclosure and warranty provisions that are included in corporate purchase agreements. Moral hazard can be resolved by contractual mechanisms that are designed to align the incentives of the contractual parties. And so I'm going to go through some examples of provisions that are often included in corporate purchase agreements that are designed to mitigate the adverse selection and moral hazard problems. The first is less of a contractual provision and more of a market practice. But the first and most basic strategy for addressing adverse selection is due diligence. So I'm sure almost everyone in the classroom has heard of due diligence, and the practicing lawyers, I'm sure, have done due diligence. But due diligence is an important method for mitigating adverse selection when you're buying a company. Due diligence is a fundamental aspect of M&A practice. And what due diligence refers to, due diligence is a sort of institutionalized market practice by which sellers of companies, or companies that are being sold, after they've signed a purchase agreement, or in some cases before they've signed a purchase agreement, they reveal to the buyer a lot of sensitive private information about the business that they would not normally disclose, right? That is not for public consumption. So they basically kind of air out the company's dirty laundry, and they disclose to the buyer in documentary form, all of the company's sensitive financial information, its operational information, its legal information, right? A lot of information that is competitively sensitive that they would not normally disclose, they reveal to the buyer in order to resolve the buyer's apprehensions and increase the likelihood of a successful transaction. And so due diligence covers a range of issues. Like I said, there's financial due diligence that's typically performed by accountants. There's operational due diligence that's typically performed by the business principals on the transaction. And then finally, most relevant for our purposes is legal due diligence. So when a company is selling itself, or a company is being sold, or a company is trying to solicit a major investment, the company will share with the potential buyer, with the potential investor, all of its sensitive legal information. So the way that this works in practice is the company will set up, these days it's online, so they'll set up an online database, and they'll populate that database with hundreds, if not thousands, of legal documents. And then buyer's counsel, who's representing the buyer in the deal, they will research and investigate these legal documents and make sure that there's no hidden landmines, right? So this is a big part of the life of a junior associate at a large law firm, for example. So if you're a junior associate at a large law firm, like I was back in the day, you will do a lot of due diligence, right? As a first and second year associate, you do a lot of due diligence, right? So you're the one who is kind of sifting through these data rooms, reviewing contracts, reviewing governance documentation, reviewing all sorts of legal documents to make sure that there's nothing off or nothing fishy. Make sure that there's no smoking guns, and then you kind of prepare a memorandum for the client, and you present that to them. So junior associates often manage this process. It's often first years who are sifting through these documents, and then there might be a second year who's kind of managing them and producing a due diligence memo. So this is a big part of M&A practice, at least at large firms, and it is very tedious and not particularly fun or satisfying. But I would encourage you, if anyone in the room ever ends up doing due diligence for months on end, you can be heartened to know that you are resolving information asymmetries. So you're performing a very important function in the transaction. I will mention one thing that's interesting about due diligence is due diligence was also sort of in solicitors' practice, in MA practice. Due diligence is kind of like sort of on the frontier in that it was kind of the first aspect of corporate practice in which lawyers started using AI. So lawyers have actually been using AI to due diligence for several years now. It's not really a new thing. And I'm not in practice right now, so I think different firms rely on AI more or less. I've talked to people in practice, partners, associates. Some people tell me that they've had really bad experiences using AI for due diligence, so they rely on it less. Other people have told me that they have good experience, so they rely on it more. I imagine that as the years go by, AI will become a bigger and bigger part of due diligence. So what I mean by AI is you're basically just feeding these hundreds or thousands of documents into software which reviews them for you and provides like a summary report. But even if AI becomes much more pervasive in that area, of course, you will still need junior lawyers to interpret those reports, right? You'll still need someone who has legal knowledge to kind of understand what the AI is telling them. So that is sort of an interesting change that's occurring in practice. But whether it's automated or not, due diligence will surely remain an important part of M&A practice. So due diligence is sort of the most basic and the least glamorous method of resolving information asymmetries. But another method, which is, again, absolutely pervasive in corporate practice, any corporate purchase agreement or almost any corporate purchase agreement will include what are known as representations and warranties, right? So for the students in the classroom, if you become M&A lawyers, you'll be drafting a lot of purchase agreements, and you'll be drafting and negotiating a lot of representations and warranties, because almost all purchase agreements include them. What are they? Representations are simply statements of fact about the company being sold that are included in a purchase agreement. Right? They are statements of fact about the company. They're sort of disclosures about the company. So, for example, here's examples of some representations. You might have a representation in an agreement that says the corporation is not involved in any litigation, right? Or the corporation is not subject to any environmental liabilities, right? Or the financial statements that have been provided by the company are true and correct in all respects. Or, management of the company is not being sued for misconduct, right? Goes on and on and on. Most purchase agreements include dozens of representations, right? So they have dozens and dozens of these statements of fact about the company. They're sort of statements as to the company's quality. They're statements that the company doesn't have any hidden issues. The representations are backed up by warranties, right? So warranties provide indemnification to the buyer if any representations are false or if any representations are inaccurate. So if a buyer enters into a purchase agreement, it has representations and warranties, and imagine that some of those representations turn out to be false, or some of those representations turn out to be inaccurate, and the buyer suffers economic loss as a result, they can then seek indemnification from the seller. They can say, hey, but you breached your reps and warranties, we suffered a $100,000 loss because of that, you owe us $100,000, and it's a pretty straightforward process to enforce that, right? So these reps and warranties, they're very similar to warranties on anything else, right? Very similar to like a warranty on a car, right? If you buy a car and the transmission is faulty or whatever, and it's under warranty, that you get indemnified, right? The manufacturer will pay for the repairs. So it's a very similar concept. Representations and warranties protect buyers in two ways. The first and most obvious is they simply provide economic reassurance to the buyer, right? So the buyer is buying a company and they're like, I don't know, this company might have some issues. They're protected by the representations and warranties, right? So if something goes bad, they can, they have the assurance that they can seek indemnification. But there's another, and I would argue more important function of representations and warranties, is that they provide a highly credible signal as to the quality of the company that is being sold, right? So who in the classroom wants to guess, like, why is it that these representations and warranties, why do they provide a credible informational signal about the company? Somebody answer this question. What is about reps and warranties that provide information in and of themselves, independent of the actual financial guarantee? What about reps and warranties provides a credible signal about the company? Yeah.
Well, if the company is willing to indemnify the cost in the event that the statement's false, then I think it makes a statement credible.
Yeah, the statement is highly credible because if it is inaccurate, the seller will have to pay for any damages, right? So a seller is not going to provide robust representations and warranties if they think the company has issues. They will only provide robust representations and warranties if they believe that the company is of high quality, right? So this gets to the heart of the information asymmetry problem. Like, how do you figure out the quality of the company? Well, if the seller is willing to put their money where their mouth is, right, and they're willing to stand by their representations, they are revealing highly credible information. They are revealing their own subjective belief as to the quality of the company. They're putting their money where their mouth is, right? In the economics of information, this is referred to as a costly signal, right? Costly signals are highly credible because if they are inaccurate, the person who is making the signal bears a cost, right? So, you should always put greater credibility into costly signals than costless signals, right? Costless signals is when somebody just says something and there's no consequences for what they say, right? Talk is cheap, on the other hand, right? Some people just say stuff and they're not backing up what they're saying. But if somebody makes a representation and they're saying, like, I will pay you if I'm wrong, that's a highly credible signal. Oops. Okay. Another way that this is resolved is through objective verification. So sellers will often pay an objective third party to verify their own disclosure. And the best example of this is simply audited financial statements, right? So when you're selling a company, you have to provide financial statements. Imagine the CFO has, they've created the financial statements. And it's some company, it's like a small company, you've never heard of them, you don't know who the CFO is, right? CFO has really, no credibility with you, no representation. You don't know if the CFO is cooking the books. You don't know if the CFO is making stuff up. You don't know if the CFO is incompetent. Maybe they just don't know what they're doing. So what firms will often do, right, is they will pay an accounting firm to audit their financial statements and verify that the financial statements are correct. Accounting firms, the way that the accounting business works, is that accounting firms have typically, over years and years and decades and decades and decades, they've developed very strong reputations for competence and credibility in accounting, right? And so a CFO or a company that has no reputation, doesn't really have much credibility with the buyer, they can pay an accounting firm to audit their financial statements. And from an economic standpoint, that's sort of like renting the accounting firm's reputation, right? You're like borrowing the accounting firm's reputation. The accounting firm is certifying your financial statement. So that's a very common example of what's known as third-party certification in M&A. In terms of moral hazard, how is moral hazard dealt with in M&A? One method is covenants. So for larger M&A transactions, just FYI, there's often a delay of several months between the signing of an agreement and the closing of the transaction, right? This is the larger, more complex the deal, the more likely there is to be a delay between signing and closing. This creates a very serious moral hazard problem because, like, once the buyer has committed to buy the company and then they have to wait several months before they sell, during that window of time, the seller or the management of the seller, they have an incentive to, in the most extreme examples, like loot the company, right? Just like take all the money out of the company, and then you're buying a substantially devalued company. Or, maybe a more prosaic example would just be like they just start slacking off, right? Because they're like, well, we already sold the company, we're already going to get the money, so they just like let the company go down the toilet, right? Both are moral hazard problems. Because of this, almost all corporate purchase agreements include restrictive covenants that prevent the seller from engaging in any unexpected or deleterious or risky behavior before the transaction closes, right? So purchase agreements are full of what are known as restrictive covenants, and they prevent the company from, basically doing anything weird, changing its business model, paying out special dividends, giving management, like super bonuses, what have you. Anything that's going to deplete the value of the company, they're forbidden from doing. Generally, purchase agreements also include an affirmative covenant to continue to operate the company in the ordinary course of business, which is sort of a term of art. But the ordinary course of business, what this means is basically just a requirement that the sellers continue to operate the business consistent with historical practice, right? Again, no surprises. You're going to keep doing what you've been doing, and that is designed to mitigate the moral hazard problem. And in between the signing and the closing, if the seller breaches any of their covenants, deal's off, right? Buyer can walk away, right? If you violate your covenants, deal's off, buyer can walk away, right? So the seller has a strong incentive to be careful that it follows the covenants that it's agreed to. And then final example I'll give for moral hazard is just earnouts. So in some deals, you buy a company, and then the sellers continue to run the business, right? So you might be a financial buyer. You buy a company, the sellers continue to run the business. You want to make sure that after you pay the sellers the purchase price, they're now running the business, that they're not going to start to shirk, that they're not going to start to go play golf, and they're going to let the company diminish in value, right? So one way of addressing this is through an earnout payment, where when you buy the company, you only pay a portion of the total compensation, and then you defer the remainder of the compensation until some later date, and that deferred payment is contingent on the company achieving certain financial milestones, right? So basically, the sellers don't get all their money unless they continue to maximize the profits of the firm. And you can structure, you can structure this as like a schedule of payments. So like if the firm is really profitable, they get like a bonus. If the firm is less profitable, maybe they take a haircut. But the idea is to align the incentives of the buyer and the sellers who are now running the company. Just one thing I'll mention really quickly is I teach in Vancouver, and BC is kind of like the world's capital of the mining industry. So there's a lot of mining M&A in British Columbia. And earnouts are very, very common in mining M&A, actually not because of the moral hazard problem. It's really interesting. Mining M&A is way more interesting than it sounds, by the way. But you often have earnout payments in mining M&A because there's neither the seller nor the buyer have good information about the value of the company. Because a lot of junior mining companies just hold speculative mining claims, and really nobody knows what the value is. So you often use an earnout to sort of basically balance the risk between the buyer and the seller, which is a different way of using an earnout. So I'm running close on time, so I'll just real quickly mention some of my research in this area, and I encourage you Google these articles, look them up, and read them. They're highly fascinating, in my opinion. But one article I wrote on this is sandbagging in Canadian law. I was being facetious, by the way. I actually quite like this article. It's like a nice little article I wrote on sandbagging. Sandbagging in M&A is basically when the buyer signs an agreement with the knowledge that the seller is in breach of some of their reps, and then immediately turns around and sues them. That's sandbagging. It's sort of a controversial practice in M&A. It's the legality of it or the enforceability of reps and warranties in that context is somewhat unclear in Canadian law, so I wrote an article on it. I basically argue that buyers should be allowed to sandbag. I think sandbagging actually enhances the strength of representations and warranties, and I think it's not a problematic practice, and I think courts should allow buyers to sandbag. So if you want to read more about adverse selection, you can check out that article. And then an article I wrote that has more to do with moral hazard is reassessing the end of history, directors' duties, and shareholders' rights in comparative context. And this article is one of several that I've written on fiduciary duties in Canadian law and comparatively. So this article actually compares a number of jurisdictions around the world and talks about how they treat directors' duties. And I guess I would just maybe close things out by saying that fiduciary duties, which is like one of the most basic aspects of corporate law, fiduciary duties were really designed by courts to address the moral hazard problem, right? So fiduciary duties were developed by English common law courts centuries ago because English courts, when they were dealing with trusts and trustees, they intuited this moral hazard problem. They didn't use the language of formal economics, but they intuited that trustees have both the incentive and the opportunity to take advantage of their beneficiaries. And so they created the fiduciary duty. The fiduciary duty is a legal duty of loyalty to someone else, right? And as I always tell my students, fiduciary duties are very serious. A fiduciary duty is like a sacred duty, right? And it's a profound duty because in many ways it kind of flies in the face of human nature, right? Human beings are self-interested. They generally do things in their own interest. The fiduciary duty requires that you martyr your own interests, right? And that you look out for someone else benevolently. Like you look out for someone else, you don't look out for yourself. So it's a really, really profound legal duty in the various contexts in which it expresses itself. And lawyers often owe fiduciary duties to their clients. So it's something that's definitely relevant to any lawyer. So anyways, that's just some of my research. If you thought this talk was interesting, I would encourage you to check out these articles. And I would just kind of end as a last note to bring things back to the beginning. If you ever move to Vancouver and you're in the market for a used BMW M2, do not buy mine because I do race it on a racetrack. So that's my presentation, and I'm happy to answer any questions.
Okay, we have about 10 to 15 minutes for questions. If you do have a question, ideally make your way to one of the mics on either side, or we can bring it to someone, but if you can make your way over there, that's best, and we'd welcome questions on any aspect of this or going deeper on different things that Professor Hutchison has worked on. So, Professor Henderson.
Thanks so much for the talk. So I was interested when you mentioned the sandbagging article, because throughout the talk I was thinking of a different problem, which is the cost of litigation. So especially for buyers, you have these reps and warranties, but then there's a significant cost to enforcing them. And you also mentioned some technological developments in terms of the use of AI in due diligence. And so I remember, I think a few years ago, when blockchain was new, everyone was talking about smart contracts and the idea that you could make these maybe automatically enforceable. And so I was just wondering if you're aware of any other developments in this space or using technology to try and make these things easier to enforce or more automatically enforceable, or if people are still talking about smart contracts or if that's all gone away.
Yeah, so to answer your question, I don't know much about smart contracts. I mean, there are academics who've kind of explored the potential of smart contracts. I'm certainly not an expert. My impression, and I'll let the practitioners correct me if I'm wrong about this. I mean, I don't think in M&A practice anyone is using smart contracts. So I think that strikes me as a bit fantastical. I don't think that that's really gained any ground, but someone can correct me if I'm wrong about that. Yeah, I mean, I don't think it's a part of mainstream legal practice.
Don't you hate it when you have professors in the room who
I
always feel that they have something to say?
I love it, actually.
So about 100 years ago, when I started teaching contract law, the idea of good faith in contracting was pretty foreign to Canadian law, particularly implied duties of good faith, where the courts would say, oh yeah, contracting parties have an obligation to act in good faith. Do you have any thoughts about how that impacts the problems that you've just outlined and is particularly a judicially implied duty of good faith in contract performance or negotiation, which would be relevant to sandbagging? Is that a good thing? And the reason and I guess one other comment is when this started to become a movement in Canadian law, there was a lot of concern about uncertainty and how that was going to affect parties in terms of what their liabilities were going to be in relation to contract performance and negotiation. So I just wondered if you've thought about how good faith intersects with this problem.
Yeah, I have thought about that. So I actually addressed that specific issue in this article. So in my sandbagging article, I actually talk about the development of a duty of good faith in contractual performance in Canadian law. And although, I mean, I think good faith is good, I think that, for example, like the doctrine that's emerged out of like Basine v. Hernu, that case, I think I don't support it. I think it's a pernicious doctrine. I think that good faith and contractual performance, and this kind of goes back to Gail's question, is highly subjective. Whether or not a party was acting in good faith, whether or not a party had knowledge over a certain breach of representation is highly subjective, and therefore leads to very, very uncertain and expensive litigation. And I mean, this is a philosophical question to a certain extent, but I believe if we're talking about sophisticated parties, like in the M&A context, where both parties are sophisticated, I think they should be strictly bound to the terms of their contract. And the question should be, did you comply with the contract or not? And I think, again, ideally we want people to be acting in good faith, but I think that can be a red herring, and that can lead to a lot of uncertainty in the business world, and I think it can lead to a lot of uncertainty in litigation. So the development that came out of the Basine case from the Supreme Court of Canada about 10 years ago, and this sort of emergence of a duty of good faith and contractual performance, I think the costs exceed the benefits. That's my view on that particular doctrine.
Thank you, Professor Hutchison, for the lecture. I have two questions. My first is that I notice in your strategies for alleviating information symmetry that these strategies kind of occur pretty close to when the transaction is about to be finalized. So they're in the contract drafting phase and doing due diligence. I'm wondering, what are your thoughts on strategies that can occur earlier in the discussion process between seller and buyer, such as like an NDA or something like that? And how can lawyers kind of assist in that process?
Yeah, that's an interesting question. So, due diligence, broadly conceived, is a long process, and it begins what is due diligence? I mean, like defining what is or is not due diligence is difficult, but I mean, certainly the business due diligence starts at the very onset of negotiations, right? Before the lawyers are even involved, right? So the business, like what is the seller's reputation? What is the buyer's reputation, right? So that is a form of due diligence. Due diligence is sort of a spectrum, but in terms of lawyers' involvements, I mean, my observation, based on experience partially, is that, clients are doing deals, and most of my experience was representing private equity clients, so these are like very specialized buyers of companies. Lawyers don't get involved in the process until relatively late, right? So the parties might have been talking about a deal for 6 months and it might have been talks were on, talks were off, but that's a form of due diligence, right? Just talking to somebody is due diligence, right? Just assessing the seller, assessing, does this seem like an honest person? Does this seem like a credible person? That's all a form of due diligence that the client is doing, that the business person is doing, that lawyers are not really involved in. And lawyers don't really come into the process until the buyer is pretty sure, right? So I guess my answer to your question is I don't know if there's a lot that lawyers can do early on in the process because the client is not willing to pay them to do anything early on in the process. So, you don't get a call from your client until relatively late stages, I feel like. So I guess that would be my answer to your question.
Okay. My second question relates to information asymmetry in the securities context, so for public companies. Recently, the Supreme Court came out with a decision on Linden Mining that suggests that information or alleviating information asymmetry should be used as the guideline for determining what is a material change or not. Mm-hmm. And I mean, I think the Supreme Court thinks it's a little bit more helpful than it actually is in practice, because information asymmetry always exists between investors and the issuer. So my question is, at what point is that information asymmetry kind of significant enough that you think it should be disclosed by issuers?
Yeah. So I read that case and I don't remember what I thought about it. Yeah, I mean, so securities disclosure, the purpose of securities regulations is to resolve information asymmetry between investors and public companies. Yeah, I mean, I think, is there any way you could encapsulate in one sentence what the Supreme Court's holding was? And then I can maybe that'll jog my memory.
Yeah, well, so they essentially say that they provide a guidance on what is a change.
Yeah.
But in terms of assessing what is a material change, they say that the company is in the best position to assess that because what is material is very fact dependent. It depends on the business, the industry. So, yeah, they essentially
it was about really focused on the change part, right?
It did, and then but they did add that for what should be disclosed is to be assessed by the seller who is in that business, in that market, and so what is a material change should just be assessed based on the purpose of alleviating information asymmetry.
Yeah, I mean, I guess that makes sense. I mean, I would think that, and I'm not a securities lawyer, or I was not a securities lawyer and I don't teach securities. My sense is that material should be would it affect an investor's decision to invest? That's kind of how I always think about material, and that seems to focus more on the mindset of the investor than the company, but the company would be better positioned to know whether a particular change is going to impact the business in a material way. So, yeah, I don't think I have a great answer to that question, unfortunately.
Thank you.
Yep.
Opportunity for other questions, as I say, to go deeper on anything or ask anything about Professor Hutchison's experience with some of this in different deals or so on.
I have another one. Somebody mentioned AI, and all the AI questions are super fun. So you alluded to this, and the poor junior associates who won't have jobs in the future. But I'm curious whether you believe, as we get more widespread usage of AI as part of M&A process, do you think that's going to help or harm information asymmetries?
Like AI and due diligence, or just AI across the board?
I'd say across the board, because I think you're right. At firms, ground zero of the usage of this was AI usage and due diligence dating back to years ago. There was a company called Kira, circa 2016, that I believe started this off. But I mean, we see this in financial modeling. I do a lot of work with venture capital and PE firms. So when we get into financial due diligence, there's models being used that leverage AI. So whether it's legal AI, financial AI, operational AI.
Yeah. So I guess the caveat, you would probably know better than me. But to just give my own reaction to that, my sense is that, and I think that this is sort of like, this answers almost any question about AI. So I think AI is a tool, right? And I think AI can be used in a way that's effective, and I think AI can be used in a way that's ineffective. So my crude understanding of how AI is used, for example, in financial modeling, how AI is used in risk forecasting, I think it's a powerful tool, and I think if it's used effectively, it would aid in resolving information asymmetry problems. But I think AI, you have to use AI carefully, and so if you use AI in a manner that is ineffective or is non-expert, I think it can make things worse. So that's kind of a mealy-mouthed answer, but I think it's a tool, and I think it depends on how you use the tool. But I think it is a powerful tool. So I think there's certainly the potential that it could help resolve some of these information asymmetry problems.
Yeah, and for what it's worth, I tend to concur in that as well. I mean, it's a tool, and we have conversations within our offices and whatnot. This isn't something that displaces your critical thinking. And I've found some interesting studies that have nothing to do with legal that talk about, ubiquitous use of AI, just handing off decision-making among professionals, and that reducing critical thinking over time. Like individuals essentially just divesting themselves of sort of problem-solving thinking, et cetera, versus other individuals who are learning with and augmenting their practice with AI, as you say, as a tool, as opposed to just saying, do this for me.
Yeah, I totally agree, and obviously we don't have time to go on an extended discussion about AI and its role in society, but I completely agree with you. I think it's a tool, and I think AI can be very dangerous. So I think that people who use AI thoughtlessly and basically just offload all of their critical thinking to AI. I mean, I think there's emerging research that shows that not only does that result in bad outcomes, it like literally can reduce one's cognitive skills. Like, I mean, it's just like very, very, very dangerous. But I think if AI is used effectively as a tool to augment critical thinking, I think it can be very powerful. So I think, I'm not a huge AI enthusiast, but neither am I an AI doomer. I think it's a tool that people will learn how to use, and some people will learn how to use it effectively, and some people will use it to their detriment.
Thank you.
Okay, in one moment we're going to thank Professor Hutchison, but if there's one more question, we could probably squeeze it in, especially if any student has been shy or so on. I want to give one last chance. So. Or otherwise, you can try to catch him after.
Yeah.
We're very grateful
Thank you.
to Professor Hutchison for speaking with us, and we have a gift
wow.
to present to him as well. Thank you for speaking
Thank
with
you.
us.